The title of today's Brandon's blog is Paying Creditors Before Bankruptcy. Ontario Court's $400,000 decision changes everything. There's a landmark Court of Appeal for Ontario decision that came out on May 15, 2025, and it sets out very clearly what you need to look at when a debtor on the eve of bankruptcy makes a payment to one creditor and not any of their other creditors. Under the Bankruptcy and Insolvency Act, there's a presumption that the debtor just before bankruptcy intended to prefer that creditor over others, and the trustee is able to recover the money from the creditor it was paid to. But there are certain defenses to that, and in Brandon's blog below, he describes very clearly the terms the Court of Appeal for Ontario laid out that need to be found in the evidence in order to rebut the automatic presumption that the debtor intended to prefer that creditor over others. My name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. If you or your company find yourself in a situation where the financial challenges are growing every day and you just do not know how to solve the problem and get out from under it, we are here to help you. Give either myself or Brandon Smith a call, and we will be able to have a no-cost consultation with you to sort out the issues, solve your problem, and get you back living a stress-free life. So shoot us a message, give us a phone call. We would love to speak with you. I hope you enjoy the balance of this video and find the information useful.
Hello everyone, I'm Fiona Ledger of Ira Smith Trustee and Receiver Inc., a licensed insolvency trustee firm, and today I'm sharing crucial information about a landmark Ontario court decision that's sending shockwaves through the bankruptcy landscape. We're talking about a staggering $400,000 case that's fundamentally changing how we handle pre-bankruptcy payments in Canada. Before diving into the details, let me explain what we mean by preferential payments. These are payments made to specific creditors shortly before filing for bankruptcy, potentially giving them an unfair advantage over other creditors. The Bankruptcy and Insolvency Act, or BIA, has strict rules about this, and as a licensed insolvency trustee firm, we've seen firsthand how these situations can complicate bankruptcy proceedings. Let me break down this groundbreaking case of RPG Receivables Purchase Group Incorporated v. American Pacific Corporation, released May 15, 2025. A debtor, Specialty Chemical Industries, made a payment of $400,000 to American Pacific just months before becoming bankrupt. The court's decision was particularly noteworthy because it examined the intent behind these payments and their timing. What made this case special was how the court scrutinized the relationship between Specialty Chemicals and American Pacific. The court's ruling established several critical benchmarks. First, they looked at the debtor's state of mind when making these payments. Second, they considered the pressure American Pacific put on Specialty, and whether the payment made sense in an overall scheme of trying to save the company and benefit all stakeholders. The court also looked at alternatively, did the payment not make any sense on its face for trying to create an environment of fairness for everyone? This decision is a precedent that we must all be aware of when handling pre-bankruptcy payments. I cannot stress enough how this ruling affects anyone considering bankruptcy. Making payments to specific creditors and not to others before filing can have severe consequences. The creditor recipient might be forced to repay that money to the bankruptcy estate, even years after the fact. This applies to both personal and business bankruptcies. When you're facing financial difficulties, timing is everything. Document every payment you make, especially to family members, suppliers, or business partners. Under this new ruling, you'll need to prove that these payments were made as part of an overall, detailed plan to save the company. Let me share some proper ways to handle your payments when you're considering bankruptcy. First, maintain regular payment patterns if possible. Second, avoid making large one-time payments to specific creditors. Third, and most importantly, keep detailed records of all your financial transactions. As licensed insolvency trustees, either Ira Smith or Brandon Smith can help you navigate these complex waters. Early consultation is crucial. It can help you avoid costly mistakes and protect your interests. We can explore various options, including restructuring plans, that might better suit your situation. This Ontario court decision has confirmed quite forcefully what the bankruptcy landscape is. Remember, any payments you make to creditors before bankruptcy could come under scrutiny. The key is to act early and seek professional guidance before making any significant financial decisions. I invite you to reach out to either Ira or Brandon Smith for a free, confidential consultation. Our team at Ira Smith Trustee and Receiver Inc. is here to help you make informed decisions about your financial future. Visit our website at irasmithinc.com or call us at 905-738-4167. Don't forget to like this video and subscribe to our channel for more valuable insights about bankruptcy and debt management in Canada. Remember, when it comes to bankruptcy and insolvency, knowledge and proper guidance are your best allies. Stay informed and don't hesitate to reach out for professional help.